Well, thank you, Danielle, and it's always an honor to be here. I was at the last conference that was held in Orlando. Instead, this time you guys have come to my adopted hometown since I've become a swamp dweller in Washington, D.C. And, it was considerably more fun and more relaxed, I think, in Orlando. For me, everything in D.C. is tinged with tension. So I thank all of the organizers and you. Since I'm a late-breaking addition, you may be looking at me, other than the quick introduction of like, who's this guy? Why is he not on my program? So I'm grateful for them slotting me in. So look, I've been in Republican presidential administrations for a long time, going back to Bush 43. So in Bush 43, I was a Deputy Assistant Attorney General in the Environment Division. And then in Trump 45, President Trump made me the head of the Environment Division and then eventually also the head of the Civil Division at the same time. And that's 1,400 lawyers. I was coming off of that those stints when I was here for a prior conference. This time, actually, seems like you didn't get the memo. So I just left last month the first year of service for the Trump 47 administration. This time around, I was not dispatched to the Justice Department, but to an entity inside OMB, the Office of Management and Budget at the White House, so just a few blocks from here, running an entity called the Office of Information and Regulatory Affairs, which is called OIRA. And at this point, you may go to sleep unless you're really familiar with Washington. Like, what the heck is I was the acting administrator of OIRA. And I left after my 300 days under some complex statute called the Federal Vacancies Reform Act expired. Now I'm back at a think tank called the Oversight Project, where I welcome all of you to follow our activities. We're filing a brief tonight, actually, to try to keep you, even while you're visiting here, safe by getting final authorization through the courts for President Trump to have deployed the National Guard here to turn around the crime wave. But I have a more common title, to the extent the media tries to translate things for people from the presidential administration. I was the regulation czar. That's what the newspapers would call me. So all of the regulations across the entire executive branch would come through me. And that includes all of EPA's regulations, and not just all of EPA's clean air regulations, like the ones related to climate, which you're very interested in, but also EPA water regulations, EPA solid waste regulations, the Superfund statute, the Federal Communications Commission, the Securities and Exchange Commission's regulations of stock market offerings. You name it, it came through me. So it was a big job, and President Trump, for the first time ever, actually made all of the so-called independent agencies subject to OIRA, to the regulatory czar. And the president tasked us, so I'm going to give you some good news before I kind of start talking about some of the climate-specific topics. The good news is that in Trump 45, President Trump tasked OIRA and the whole administration with pulling down 2 regulations for every 1 new regulation that he put into federal law. And that goal was met. And so this time, President Trump decided he was going to set an even more ambitious goal. And in an an executive order that he issued in January of 2025, he demanded that we actually achieve a 10-for-1 or more deregulatory ratio. And so we had to pull down 10 regulations for every new one that went in. And so I'm here to report to you, maybe I'll even, sometimes I get spoilers. I spoke recently at the Yale Law School to conservative law students there at the Federalist Society, and one of them actually had looked this up, so he's kind of ready for me, but maybe I'll catch you guys by surprise. So after the first year of the Trump administration for fiscal year 2025, what ratio do you think we achieved? And we exceeded 10-to-1. How much do you think we got to? 27-to-1, did I hear? What else? No, it's higher. Higher. Higher than 98. We got to 129-to-1. So President Trump's deregulatory agenda is the most ambitious deregulatory agenda in history, and that record of accomplishment is unmatched, and I'm pleased to have helped President Trump for that first year. Now let me ask you, okay, you might say, all right, well, you're pulling down all kinds of things, but they regulate everything under the sun. You can pick up a unit credit for every time you bump off something even small, but let's aggregate it. Economically, I can tell you what the result is, and that's also impressive. So I'll tell you that in the second year of Trump 45 administration, his first term, so that was 2018, fiscal 2018, the total net amount of deregulation netted against new regulation was about $24 billion. So this time around, for fiscal 25, the first year of his second term, and you have to keep in mind it's only sort of part of a year because of when it starts with when you take the oath of office and get inaugurated, that was $212 billion. So in the first year of the second Trump term, we exceeded by almost an order of magnitude the amount of deregulation done in the second year of the Trump administration. So these are, thank you. These are very impressive numbers. I am going to talk about the endangerment finding and my history about it, which is probably the subject that was most interesting in grabbing me here for a presentation. But first, let me highlight something for you that I think has not gotten sufficient attention in the, I'll call it, conservative libertarian community, which is our total destruction of the California electric vehicles mandate. So the California, under their crazy leftist governors and the California Air Resources Board and the California legislature, they'd mandated phasing out conventionally powered vehicles, the internal combustion engine, and they were going to have all electric cars. And the way that works under the Clean Air Act is that, so let's go back to what I'll call the Clean Air Act kind of dawn of time. So before the Clean Air Act kind of comes in around 1970, in the 60s, California is experiencing a massive problem with smog. And that's because of the fact that it becomes a driving culture. If you've driven in California, I have, there just seem like there are freeways to everywhere, and constant jam ups and the like. And this kind of started early, and it's also in a geographic situation where you got the sea and then you got the mountain, and the air kind of gets trapped, and then you have a smog problem. So they decided they were going to solve the smog problem with their own state regulations. But then along came, especially with the growth of the environmental movement, the Clean Air Act's passage in 1970, and then big amendments in 1977. And as part of that, Congress decided in its wisdom that for car manufacturers, right, you don't want to have 50 different cars you have to manufacture for each of the states in the country, right? It would be chaos. You couldn't achieve economies of scale. And so we just have to have one national regulatory standard that the auto manufacturers in Detroit back then, now we got a lot of international competition, could hit. But California said, hey, wait a minute, we've been regulating before you guys got here. We need a special exception. And much to my personal disappointment, since I spent a lot of time in my career in private practice when I was not in government fighting against the California Air Resources Board, they got a special exception. What they can do is they can go into EPA and they can say, hey, we would like to regulate more stringently than you because we have special air quality problems here in California, especially in LA, which is usually a severe non-attainment area under the Clean Air Act. And if they can make certain demonstrations, the EPA administrator will grant them an exemption from preemption, a waiver of preemption, it's called. And what that means is the supremacy clause doesn't kick in and the Clean Air Act does not prevent them from regulating. They're allowed to have their own standards. And this is why nationally, sometimes you might even notice it if you go to buy a new car, you'll sometimes see, does it have the California emissions package? A lot of times the manufacturers will make cars that just even meet the California standards, so it's easy and they can just make one car rather than a potential 49 state car and a California car. Then, also in Congress's extreme wisdom, in 1990, they amended this regime to allow other states to borrow the California system as long as those standards are identical to the ones in California, so-called identicality requirement. So, now you got actually I forget the precise number. I think it's more than a dozen states at this point. 16? Somebody tell me? You guys whispering? 16? Okay. So Bruce knows it's something on that order. And so you have the manufacturers producing, a kind of 16 state car and a car for the rest of the country, right? Unless they want to decide to voluntarily build everything up to the more stringent California standards. Okay. Using this power and going to the Biden administration, they got preemption waivers for their electric vehicle mandate to try to wipe out all conventional cars in California and just have electric cars. So I've been critical of Congress in terms of what they've done in the Clean Air Act and the Clean Air Act 77 amendments and then the 1990 amendments. But here's something good that Congress did on the deregulatory front. They passed something called the Congressional Review Act. And what that provides is that when a new regulation is passed, it has to be sent to Congress. And Congress can pass a law, which in this instance they call a concurrent resolution. And if they pass that law, they can override the regulation. And then it has a special bonus feature, which is if Congress does that, if both houses pass such a concurrent resolution and they wipe out they wipe out any regulation. It's not just an environmental regulation, it's not just the California auto situation, but here, if they pass a resolution to override the preemption waivers, then California is out. And it's not just that those regulations are gone and then California can come back and do them. The statute, the Congressional Review Act, the CRA, provides that all substantially similar regulations to those California regulations are blotted out forever. In order for them to get those regulations back, they'd have to get a targeted new statute passed and through Congress allowing them to do that, which is a tall order, especially in our kind of gridlocked world. So Congress passed that at the start of the Trump administration. They blotted out 3 of these preemption waivers that were supporting the California electric vehicle mandate. President Trump, and I was there in the East Room in the signing ceremony when President Trump did it, he signed those into law. California electric vehicle mandates, dead, and hopefully permanently dead. Now, if Gavin Newsom becomes president, the left is creative. I'm sure they'll try new ways to get around that. Or maybe they'll get a new statute passed if they manage to get enough strength in both houses of Congress. But at least for the moment, the country is safe from these wacky electric vehicle mandates. And that is a major accomplishment that President Trump has already achieved. Thank you, Chuck. So now let me turn to the endangerment finding. And I have a long history with the endangerment finding. And the endangerment finding starts at an earlier stage even than the actual finding in the Obama administration, which is a case called Massachusetts versus EPA. So we have to take you back now to the Clinton administration. Clinton administration gets a rulemaking petition from a purpose-built group called the International Center for Technology Assessment, which looks to me to have disappeared from the map. So some leftists funded this group called ICTA. They filed a rulemaking petition and they said, we want to regulate carbon dioxide and other greenhouse gas emissions from new motor vehicles and engines. EPA, please do that. And the Clinton administration sat on it. They didn't do anything. And one reason why they could do that is that under administrative law, they really don't have a particular obligation to act on any timeline. But what did they do when President Bush, the younger, got elected? They decided to leave us a birthday present and going out the door, you coming in present. They put the petition out for public comment, and then that teed up the need for us to resolve it in some way. So in Bush 43, we denied the rulemaking petition. It was challenged in the DC circuit. I had a very heavy hand with the career people who reported to me and were not happy about following my instructions. But I argued that case in the DC Circuit against the state of Massachusetts, which joined this tiny group, ICTA, and I won. I won 2-1. And then I returned to private practice. I had a young family, wanted to make some money. I worked right across the street at the old offices of Kirkland & Ellis. I thought the world was safe from this nonsense, but no such luck. The DC Circuit did reject the en banc petition, so the full court didn't take the case, but the Supreme Court accepted cert. Sadly, my former colleagues in the Solicitor General's office, because they take over Supreme Court cases, they flubbed it, and they lost 5-4. And then the Bush administration double flubbed it, because they could have just gone back to what the Clinton administration had done and sat on the petition and not do anything and leave office. But no, some genius decided they were going to put it out for comment again. And they also decided to put it out for comment. Just think of how dumb this is. And I can be critical of an administration even that I was a member of, because I was certainly telling them not to do this. The political people put out statements in the Federal Register notice that said it would be dumb to regulate greenhouse gases. It would be disastrous for the national economy. There are very serious scientific questions here, like we wouldn't do it. But they also put out EPA career people's view that it was lawful to have these regulations, that they would be a good idea, and that it would not be economically disastrous. And the two things went out together. And then that was what the Obama administration picks up. So they come in 2009, and President Obama puts together his team. He gets a very bright leftist law professor from Georgetown, a woman named Lisa Heinzerling, who was a Justice Brennan clerk and a Judge Posner clerk on the Seventh Circuit. Very, for those of you who don't know, very stellar legal academic credentials. She writes a plan for them to issue a series of 4 rules, the first of which is the endangerment finding, and then boom, we have climate regulation for the first time in history. And then, now I'm in private practice, I challenged the endangerment finding. The DC Circuit ruled against us, but we did manage to bring down one of those rules in the Supreme Court in a later case called UARG that Justice Scalia wrote. So we had a partial victory, but we didn't have a complete victory, and the endangerment finding was still on the books. I was part of efforts in Trump 45 to get the Trump 45 administration to pull down the endangerment finding. President Trump did pull out of the Paris Climate Accords, which is great, and then he pulled out of them again in Trump 47. Could not get across the finish line pulling down the endangerment finding in Trump 45, but I don't give up, and the people I work with don't give up. We did get it, a final rule pulling down the endangerment finding in the Trump 47 administration. And so now, I can't claim that that's, there is some litigation about the Congressional Review Act pull down of the California electric vehicle mandate, but I just don't see how that could possibly survive. Far more of a case that's going to be a real fight, first in the DC Circuit, which one of your earlier speakers said had been stacked against us. That was current governor, former AG of West Virginia, Patrick Morrisey, who I worked with on all these things over the years. And it is stacked. It was stacked by President Obama. So it's going to be hard to win there, because we're probably going to get a majority Democrat judge panel there. Hopefully, maybe we'll get a majority Republican judge panel. Maybe we'll get at least one Republican judge to dissent. But we're going to have to fight that through the DC Circuit. I think everyone anticipates that the issue of the endangerment finding is so huge and so costly. I've seen good estimates that I believe from very solid economists that it costs the national economy tens of trillions of dollars, okay? So, and this thing is foundational not just for mobile source regulation, the cars I talked about, but for stationary source regulations and things like the Obama Clean Power Plan. So being able to permanently inter that and stack up, feet and feet of earth on top of it so it can't, become a zombie or a vampire is the goal. But I think everyone realizes we're going to have to do that in the Supreme Court. And if we can, it's a question of can we hit, a a home run or at least a stand-up double or triple or something like that, just to preserve pulling down this endangerment finding, that would be great. A true home run, which is what Governor Morrissey at lunch was arguing for you really should happen, is it would be great after his win in the West Virginia versus EPA case, which instantiated the so-called major questions doctrine, that if you have a major question of economic and vast economic and political significance, then you need an especially clear statement from Congress in order to regulate, and that doesn't exist as to anything related to climate. Then we could really hit the grand slam. What would the grand slam be? The Supreme Court saying, you know what? In Mass versus EPA, we said that carbon dioxide was an air pollutant, which Justice Scalia mocked in dissent. He called it, your theory that anything that enters the air is an air pollutant it means that everything from frisbees to flatulence could be denominated as air pollutants, right? To permanently get rid of that and have the Supreme Court say, you know what? That was relatively ambiguous text. We don't see a clear statement in the Clean Air Act that you can regulate for climate change purposes. And therefore, the major questions doctrine applies. And therefore, EPA was right to repeal the endangerment finding. And then the thing can't come back unless Congress passes a totally new statute, which again, is a very tall order. So with that, I will leave it there and turn it over to the next speaker.